Pankaj sir, are you available?
Yeah, I am available. Khetan.
Okay, sir. Okay. So, good afternoon, everyone. I welcome you all in today's webinar series on the topic reviewing of regulations under IBC. So, we have started this new webinar series wherein we will review every regulation every Wednesday, and the report on the feedback of all the insolvency professionals will be shared with IBBI. For today's webinar, we have Mr. Prashant Sarangi sir also, who is the Managing Director of ICSI Institute of Insolvency Professionals. Sir, would you like to say something?
Thank you, Nitika.
So
I welcome you all to this session of webinar series. So in this webinar series, we are planning for 9 sessions where we will take your valuable feedback, and based on your feedback, we will submit our feedbacks to and our report to IBBI. So IBBI, I welcome the officers of IBBI who are also joining in this series, and I also welcome Pankaj Khetan sir to this session. And I all know that today's session is on a particular topic of CRP. So I welcome you all again and hope that this discussions will be fruitful and will get a valuable suggestion and comments from our members. So thank you all. Thank you, Nitika. Over to you. Nitika, over to you.
it was not very clear. Okay, sir. Okay, thank you. So for today's topic is on reviewing the CIRP regulations. We will review CIRP regulations in 2 parts today, and one CIRP regulation discussion. We have Mr. Pankaj Khetan sir. He is the fellow insolvency professional who has handled many assignments of CIRP liquidation and voluntary liquidation. So Pankaj Khetan sir, he is the moderator for today's session, and this session is an open-ended session. So everybody can participate in the discussions and they may have deliberations on the topics, and then we can share the consolidated report to IBBI on all the regulations. To you.
Yeah, good evening, everyone. I am audible.
Yes.
Yes, sir.
Good evening, sir. Good evening. Yes, you are audible.
Good evening.
Good evening, sir.
Good evening, sir. Thanks a lot to the ICSI IIP for arranging such a vast webinar, for giving a suggestion to the IBBI. This suggestion shall be based on our experience. What I think we should mute. Mr. Govind said I am muting you so that nobody can disturb. Yes. IBBI, while its circular dated 4th May 2023, has asked for the suggestions on the CIRP. What the practical problems we IPs are facing, as well as what the theoretical things mentioned under the Act and the regulation. So CIRP and IBC code came in December 2016. Already 6 years has passed. Now IBBI is looking for some suggestions what the improvement can be done on the practical experience of the professionals. So we should go one by one each regulations. It's a open-ended session. I am not the faculty. I am just the moderator. So I would like each and everyone to give their fair suggestion. What difficulties you people are facing during handling the assignment, right? So, Nitika, can you share the slide for CIRP regulations? So we will cover it. CIRP, there are total CIRP regulation 40D. Till 40D, IBBI has notified the CIRP regulations. So we will cover it in two parts. Today, from regulation number 1 to regulation number 25, we will cover. And in next Wednesday, we will cover the rest of the regulations and fast track regulations. So regulation number 1, it's the same thing, nothing to improve. Nitika, next. Yeah, now regulation number 2, it's the definition. It's a very important regulation. So in my view, there should be some correction in class of creditors. I might draw your attention and your suggestions. So anyone want to change, say something or give some suggestion in this class of creditors definition? It's open-ended session, sir. All are welcome. Any views? Do participate, sir. In my view.
Sir,
Yeah, please. Yeah,
sir,
please.
with respect to class of creditors, there's workers and employees. Workers will have unions, trade unions.
Yes.
Normally, these employees will not have any unions. In case multiple applicants are joining together and filing an application before NCLT, how the authorized representative is appointed? Is there any requirement for unions or associations to be formed, or the other members should authorize only one person? How it is, sir?
Yeah, that's a very good suggestion. There is no clarity on that topic because class of creditor has came only for the home buyers. If we go by the definitions and by the further regulations, class of creditor is only for the home buyers or real estate applicants. So there is no where mentioned how the employees union will be treated. Trade unions has been mentioned, and a lot of decisions from different NCLT, rather Supreme Court has come. But nothing is there on employees association or group of employees, because now the limits of filing the case has increased from 1 lakh to 1 crore. So first of all, my suggestion is to decrease this limit. Second thing, your suggestion is very right. There is no word mentioned for the employees, group of employees or employees association. So here I would like to insert to suggest that IBBI should insert the something about the employees association, or they should mention whether how many employees will together combine and file an application under section 7 or 9. So that's a good suggestion. Any other one?
Thank you, sir.
Another thing, am I audible?
Yeah.
Another thing I think which is related to this, that there may not be time limit for going to form about any opinion about a class of creditor, because some class of creditor is also being formed for debenture holders or any type of depositors in the company. And in that case, if the depositors and the resolution professional may have the independence to not to go for that limit at any stage, if there would be, he has the opinion that there are class and there is not the deposit holders are related party, he should form the class. He should go for another
Okay.
representation from the deposit holders through by appointing two uh, by appointing the uh, two of the resolution professional as authorized representative out of three given. So there should not be any time limit that is within this thing, because to get the books of accounts of from the from the debtors is a
Or
huge task.
we should keep it in very matlab in clear manner, because we have the time constraint and we have to cover a lot of things. So what's
So
your suggestion for this?
it should be at any stage. There should not be any time constraint at any stage. If the resolution professional is of the opinion that there should be formed a there should be formed a class of creditors and authorized representative would be appointed for that, he should have independence for that, because if there
Okay,
is a time limit, then it is not being
well taken,
valuable.
Mr. Rajan, well taken. Second thing, in this class of creditors also, there is no provision for advance for supply of materials. In big corporates, materials in big corporates, advance has been given and material has not been supplied. So they are not the operational creditors. Some NCLT has taken the view that they are not the operational creditor. Some NCLT has taken the view that they are the operational creditor. But there was no supply of material. So where they had to be covered? How they will file their application?
Why should they file any application, sir?
For recovery of their dues, sir.
But nothing has been supplied. You mentioned that.
Nothing has, and they have given the advance, 10% advance.
That is, company has given the advance to the operational creditor.
Yeah, company has given the advance for supply of material.
So then
but
he will come
that
under a
company is
debtor
not
only.
supplying the material.
Then he will come under a debtor only, not creditor.
Sir. I have given, my company has given some advance to company B.
Sir, other creditors we can take, sir.
But there is no
Other.
definition. There is no definition for filing case under section 9 for other creditors.
Other creditors, yeah.
Only operational creditor has right to file the application.
That's fine.
It is a financial creditor in that case.
Sir, there is no, some NCLT has taken different view, some NCLT has taken different view.
Then you should be referred to the Supreme Court.
Yeah, but if it is clear in the regulations, then this ambiguity shall be removed, na? Because
Mostly it will be-
financial for financial creditor, you must be a time value of money.
Yes,
Commercial effect of borrowing.
Yes. So there should
That is
not be any
operational
commercial
Yeah.
commercial
That is the
effect of
operational
borrowing.
purpose that is being treated as operational creditor.
Sir, I told you, na, different NCLT is taking different views. So there must be some clarification where they will fall.
Yes. And
Okay.
I concur with your use of.
That you have, sir, rightly pointed out that as the COVID situation is now out, so the time, so the limit of 1 crore now should be taken down, and should be around 1 lakh or 10 lakh. That may also be given.
Okay. Limit.
That you have also pointed out rightly.
Exactly. Now come to the next.
I wish to add one thing. You say
Yes,
now
Mr.
that
Prashad.
they say the COVID effects have mostly subsided, the limit should be restored. Say like if not to 1 lakh, at least for operational creditors, it should be limited to 10 lakhs, and
Obviously, that's
financial
why I'm
creditors, it
saying.
should be from, say 25 lakhs also.
See, due to this, MSME sector is badly hidden.
Yes.
Yes.
Next.
Sir, I have one more thing.
Yeah,
The
Mr.
class of
Shiv.
creditors.
Yeah, Mr. Shivkumar.
certain NCLTs and NCLAT have ruled against landowners, you know, and
Yes.
it's very difficult doing a resolution without the involvement of landowners also in real estate.
Exactly. Exactly.
That may have to be clarified upon.
Okay. Landowners. Yeah. Land development agreement between the landowners and the builders.
Correct.
CIRP is against the builder.
Joint development agreement. JDA.
Yes. Land agreement. Very good.
Sir,
Now,
for the,
Nikita, come to the next slide.
Sir, I have one suggestion now.
Yeah, please, Gulshan. Ji.
Yeah, class of creditor has a relevance to the liquidation regulations also. And it is creating a hurdle in the liquidation SCC meetings. Because their mandate is given to liquidator that you shall, the SCC shall comprise of all the creditors. And in case
that will be covered under liquidation regulation.
No, sir, liquidation regulation under we will not able to refer this definition.
Right.
Liquidation regulations refers to the CIRP regulation. So for SCC is concerned.
Right.
So in case of CIRP, only financial creditors are the members of COC.
Right.
But in case of SCC, all the creditors form part of SCC now.
Right.
So their problem is in case there are workers, 9 workers, for instance, 9 operational creditors, 9 financial creditors. So we cannot constitute a class of creditor in that case. So the number of committee members becomes so fragmented that it is difficult to invite, call a meeting and have a meeting in a proper manner.
Okay. So what's your suggestion?
My suggestion is that this number of creditors for forming a class should be brought down for the purpose of SCC meeting.
So that we will cover under liquidation regulations.
Okay, fine.
Right. Nikita, next slide, please. Nikita? Yeah. Then I think there should be perfect fair value, valuation metrics, identity. These are common things. Next slide. Drop down. Liquidation value same, participant ठीक है, registered valuer. Yes, yes. There is a time. Yeah, चलिए आगे. Next, record or evidence of default by financial creditor. Any suggestion? Anything has to be changed in this regulation? No suggestion. That's simple. ठीक है.
Due and default simple.
Next, Nikita, next. Come to regulation 4.3. Eligibility of professional, it's perfectly fine. Next. Come to 4. Assets to the books.
Yes, sir.
Assets to the books.
Yes.
Assets to the books. Sir,
I have a suggestion.
kindly throw light with your practical experience.
Access to books is allowed. If they don't, you have 19.2 to go and reply present before the NCLT, and it takes its own sweet time to get an order or a direction only. And
So
even
what's the solution? What's the solution, sir?
even after the direction, the records may not be coming. Maybe this particular access to books and other records can be strengthened by imposing a penalty on the suspended directors if not produced within a week's time from the date of demand by the RP.
It should be a time bound, yes, exactly. Within a stipulated time.
It will be time bound, but who will impose the penalty? NCLT, adjudicating authority?
No. If it is reported,
Yes, it should be by IAA only.
as if you file under section 403 of the Companies Act, these their delay will be automatically fined on the suspended directors. and they should be forced to pay that.
Sir, now question comes, if our IRP has asked for 20 things and he has supplied 10 things, then?
Sir, I feel there should be a standard format which should at least be provided to the RP through an application made by the IBBI.
Rodaji, different industries had their different set of things. So we cannot.
होता क्या है कि जिस समय हम बुक्स मांगते हैं, हम 19.2 करते हैं, वो कहते हैं जी मैंने तो दे दी, एक स्टैंडर्ड बुक का फॉर्मेट हो, वो वहीं पे अपलोड करे कि ये इस फॉर्मेट के मुताबिक ये मेरी इलेक्ट्रॉनिक बुक्स आ गई, so that he cannot withdraw back कि बुक्स आई कि नहीं आई.
Okay. So electronic
problem is he'll always say कि मैंने तो आरपी को दे दी जी.
Exactly.
आरपी ने कब्जा ले लिया, वहां पे उसको मिल गई.
Very true.
No, actually,
होती नहीं है.
No, actually.
हम जिस दिन कब्जा लेने जाते हैं, हम एक बुक का रिकॉर्ड बना नहीं सकते कि इसमें ये है, इसमें ये नहीं है. वो तो बाद में बनेगा. Let it be uploaded.
Sir, if promoters are not supporting, then how can we expect?
Sir,
promoters are not supporting, they will not upload it.
सर उनके ऑडिटर्स को भी अकाउंटेबल बनाना होगा सर.
Exactly. But
sir,
as per the companies, auditors are not required to keep the books.
Yes. तो अगर वो कहता है ऑडिटर के पास दे देते हैं, then we have to run after the auditor. What is it?
No. They cannot say कि books are with the auditors.
Exactly. They say umpteen number of.
They say, but it's not legal
exactly.
Viable. Huh?
Sir, actually, sir, 19. Sir, I am sorry to say, 19.2 should be made stringent, sir. Simple.
Sir, चलिए 19.2 when we will cover.
Effective ही नहीं है sir. वो तो एक as a routine basis में हो रहा है. उसका कोई effect ही नहीं है.
Sir, now we have to ask for the NCLT to fasten the decision.
Exactly.
Anyway.
And
now regulation 4A.
I have some suggestion on it, sir.
Yeah, please, Guptaji.
Sir, for this non-cooperation on account of books of accounts, I suggest that when opportunity of hearing is given to CD and directors, they should be asked to file all the due returns to MCA, and instructions should be given to MCA, ROC also, that file and reply or affidavit that all the due balance sheet and returns are submitted. At least annual return and balance sheet should be submitted prior to that date.
Okay.
I think of section 9. At least we should have, we will have a 1 year record with us. At present, we are not having even balance sheet of 7-8 years prior to CIRP date.
Even as of now, yeah, all records are filed with the MCA. If they don't file, how do you get it?
How
if
you get
the record it is filed, you can definitely download. There is no need that you should go and beg them.
No, sir. Even in case company is not submitting returns to MCA, how we can download it?
No, his contention is, sir, MCA should enforce that. MCA should have a mechanism whereby they are forced to file.
No. That will be that's not the solution, sir. That's not the solution. No ministry will take this burden.
They will not take on their head.
One thing what we can think of is also in the Companies Act. If you see, for winding up process that is given in the Companies Act, it is deemed that it is in custody of the liquidator, the assets, etc. is in custody of from the day of the order. It shall be deemed the assets are in the custody of the.
That's a different view. That's a different thing. That's a voluntary liquidation.
From the day of order, if we can say that irrespective of whenever it is submitted, maybe delayed submitted pursuant to CIRP order, it may be presumed that it is in the custody of the IRP. And secondly, also about it can be considered as hindrance to the CIRP and section 70. So if it is possible to look at from that angle instead of just looking at direction, because direction is already given in the main CIRP order to provide and cooperate, etc.
Section 70 has to be application has to be filed by the IBBI.
Right.
Exactly.
In the special court, and I was the first IP who filed first application under section 17.
सर जो लेटर हमने भेज दी है वो कपिल शर्मा के नाम से भेज दी ना?
I have one more suggestion on it, sir. I have one more suggestion. This is important matter, sir. I request to have some deliberations on it.
Yeah, please tell me.
When opportunity to CDA is given, then he should file an affidavit or undertaking that all the due balance sheets and returns are submitted to ROC. Whether submitted or not, at least he should disclose on it.
Sir, practical issues आते हैं when the company is closed, then the promoter says कि I don't have any employee. These are the books. These are the books you take in your custody.
That may be an exception, sir, but for routine matter where directors are fighting for admission of application, at least in those cases, NCLT should direct considering the regulations on rule book.
Sir, we cannot make regulation on fraction basis. Na? Regulations shall be made after considering all effects. So
Sir,
we should not pick and choose the thing.
Sir, I suppose befitting solution is penalty, sir.
Okay. Penalty.
Imposing penalty is the best solution, I think.
Penalty with timeline.
Yes. And auditors are to be taken to in a loop.
No. Auditors cannot.
Auditors cannot be taken into the loop.
Yes. Next slide.
19.2, sir. In 19.
Yeah, 4A, regulation 4A, choice of authorized representative. Any point to suggest?
Yes, sir. I have one question.
Yeah, please.
When I give the consent as authorized representative, it is not possible to upload it on IP1 form in IBBF site.
And it's not that related to CIRP regulation?
No, it is because after this consent only the IRP will select this thing. No? He will mention the name on this public announcement.
Okay.
So I have to upload my consent on IBBS site in IP1 as I do it as liquidator or IRP. But then there is no option in that IP1 whether IP1 can be amended accordingly.
Okay.
This is not related to this regulation, okay, but on IBBI form.
No, ma'am, we will discuss that thing under the forms when we will discuss the forms.
Okay, thanks.
Next slide.
Subsequently appointing an AR is not there. Appointing subsequent in 4A, subsequently appointing an array. In the initial stage itself, the books of accounts is not available. Even he is not able to identify the class of creditors. He has no option. Subsequently, he find out that there is a class of creditors. He has no option in the 4A, section 4A.
Okay. Under this AR, my suggestion is there is no scope for change of authorized representative with the IP.
Yes, that is also there.
Only NCLT can do this.
Sir, the discussion paper which has come on 7th June, there are provisions. They have already taken it into the consideration, and quite a nice provisions have been introduced. There means 1/10 of the class of the creditors, they can suggest the change of the authorized representative.
Yeah, that is under discussion paper.
Correct. It's
yes. That is under discussion paper.
Yes.
So everybody is not aware about this. That's why I put this point.
Agree, sir.
It is on discussion stage, whether we have to find some other way or it is okay. That's why I put this point. Anyway.
One suggestion, sir.
Sorry?
Sir, one suggestion. The class of creditor can be identified either from the books of accounts or from the claims received. What will happen if books of accounts the CD is not giving? That will delay the process.
Right.
So either it can be from books of accounts or from the claims received. The IRP can appoint the...
Sir, class of creditor will depend upon the nature of the industry. If the builder is there, then we have to appoint the class of creditor.
No, suppose in the case of home buyer matter, there will be 100 of home buyer matters, sir.
Yeah.
So, if the erstwhile management is not giving books of accounts, IRP will have a difficulty in finding out from which place majority of the people are coming. So the suggestion can be either from the books of accounts or from the claims received by the IRP.
Sir, from claims received, books
Correct.
of account, so
Either-
by that time, you have not received the books of account.
Yes, sir. Correct, sir.
Okay. Now next, regulation 5, extortionate credit transactions. Any suggestion? I think it's okay. Regulation 6, public announcement is okay.
Public announcement, the date of receipt of order, that should be maybe clarified.
Yes.
And
Yes. Regulation 6. Sir, kindly mute it, kindly mute. Regulation 6, public announcement.
yes,
There is no clarification, and even in some disciplinary committee has taken different views in different orders. The IP has to publish the publication within 3-4 days, whatever the time limit has been prescribed. But what happens when the IP received the order? After 10 days, 14 days, certified copy of the order or NCLT did not publish the same on the website. When order is not in public domain, then how can IP start the work? That is the main question. Whether IP has the certified copy of the order or the order has to be on public domain on NCLT website.
There is one more thing, after giving the advertisement also, the penalty has to be paid for non-compliance for that number of days.
So
while filing the CIRP form.
Okay.
That is also happening on that account because of the delay in coming. And one more item,
so here,
you have to find out, the RP has to find out what are the main places of business. See, first, it is very difficult to grab details from the promoter. They may or may not disclose. Unless it is available in the MCA website, you may not be able to find out. If it is a private limited company, it is very difficult for us to find out the number of places where they are really doing the major business. So that's also a good question.
Exactly. So here my suggestion is IBBI must clarify on from which date the timeline shall start. 180 days will start from the date of publication of the advertisement or from date of the order.
From the date of the receipt of the order, maybe reckoned with.
Yeah, that's a different NCLT has taken different views.
राहुल 26 का इसका last date है.
That is why we
इसका
should
23
recommend to the IBBA to take care of this suggestion and amend accordingly.
Exactly. So,
Sir, in fact, all CIRP forms should also carry the date of the order as well as the receipt of order by RP. Now we are only putting in the remarks column that the order was received on this date. Whereas the order was received in October. Receipt is only in December. Then only you go. See, already 2 months have lapsed on that.
That's true. That's why it's our suggestion to clearly mention if from which date the matter shall assume to be commenced.
That needs to be a clarity on it.
Okay. Now, regulation 7.
So in some cases, we have to upload the advertisement on website, but have no control to upload it on website because it is not allowed by the promoters.
Sir, here when there is no website, then what the IP will do? There is no provision under regulation. Simply, it has been mentioned that you have to publish on the website.
No, website of the
website. There is no website. That's all.
Website of the CD.
Website of the CD, na?
Yes.
When there is no website of the CD?
No, that's okay. In case there is no website, but in case there is a website of the CD and promoters are not cooperating to upload it on the website,
Exactly. वो promoter always says कि it's my technical person was looking after my website.
Yes, then how
I
can
have outsourced that, and we have not paid the dues for the last 5-6 years. So they are not listening.
Then how I can
Okay, now we
comply?
can go for a new website, Pankaj.
Sir?
We can go for a new website from today onwards.
Sir, who will pay for it? Who will pay for it?
It will be a
Even your
part of
fees
the
is not paid.
cost of the
No
CIRP.
COC will approve this.
That is right,
No
but it is a
COC, no,
mandatory requirement. So no COC can deny that.
Mr. Prasad, I am not agreeing with you on this point because I have handled around 23 cases.
Okay.
Be practical to that, sir. None of the COC.
Yes. That's why I'm saying it's not practical feasible.
Sir, even if we read that Regulation 6, it talks about 2B subclause 2 and 3 on the website if any of the corporate debtor, and on the website if any designated by the board for the purpose. I think the board IBBI, here it is referring to IBBI. They may designate a website where we can upload it. So that's not.
Yes. That is there, and you have to intimate everything to the IBBI.
Correct.
Public advertisement and
IPA also. Concerned IPA also you have to intimate, and you should upload in the IPA also.
Correct. So there's no need for going for a new website.
New website, yes.
Because CIRP cost, it's going to increase the cost and all those things.
Next, claims by operational creditors. Any point to suggest? Claims by operational creditors. Any point to suggest?
Pankaj, one more thing is that, this period of public announcement is too short. I think it should be increased to 5 to 7 days.
5 days. It should be 5 days. It will be good, sir.
5 to 7 days is good enough. 3
days
days is too short.
Yes, 5 is 5 days should be much
reasonably well.
5 days for.
Yes, sir.
Correct.
So majority decision is 5 days.
Yes, sir.
Definitely, sir.
Yes, sir.
Okay. Next, Regulation 7, claims by operational creditors. Any suggestion?
Almost the repetition of the previous regulation. I don't find any big change in it.
Okay. I don't think there is any suggestion for Regulation 7, 8.
No, not so big, sir. Not
8A, 9, 9A. Substantiation.
Pankaj, in claims of creditors, one more suggestion is that, some kind of supporting documentation should be given the time constraints. The document should also be, submitted along with the claim. So some explanation or illustration should be given what kind of documents need to be submitted along with the claims so that there is no time wastage in investigating the claims.
Sir, it depends upon IQ of the IP. Okay, how they will verify the claim.
No, but if document is given, then it's easier.
Yes. So board cannot say ki in industry wise you have to provide this document. So whosoever will file the claim.
Say about the verification by the IP.
Yes.
Can IP have the authority to categorize the creditor? If someone has submitted the claim as financial creditor, can IP consider that as other creditor? Can that authority extend to that extent to categorize the creditor?
Yeah, they can. It's the duty of the IP. If any OC has filed its claim under a financial creditor, then how the IRP will admit that claim under financial
my
creditor?
concern was, because that amounts to an adjudication, my concern was that either you can accept it or you can dispute it, but you cannot categorize it.
No,
you has filed it.
You have to mention it to the COC. See, I have received this claim. They have submitted this claim under the financial creditor head, but as per my opinion, it should be the operational creditor. So IRP duty is to verify and tell everything to the COC. You cannot adjudicate the things.
Correct. So when you are changing the category, whether that would not amount to an adjudication because someone has claimed something and you are changing that category, either you can
you have to give you cannot change. You have to give your opinion to the COC.
Justification.
to the COC. I have received 10 claims, and out of 10 claims, one person has filed its claim under financial creditor, but it seems it is the operational creditor. Then it is under adjudication, under verification. You can ask from that creditor how you fall under the financial creditor. Kindly explain.
No, what happens is, in one of the case where I am having, there are few gala purchasers are there, and gala purchasers have rightly submitted their claim as a financial creditor. But IRP has, by their own motion, they said they are all under other creditors.
सर वो मेरे को फीस पे कर देना, मैं आपको अलग से गाइड कर दूंगा.
The reason being, whether IRP has that authority to categorize differently from what is claimed.
Sir, IRP duty is just to verify and intimate to the COC.
Understood.
Right. Then regulation 10. I don't think any suggestion is required. It's clearly mentioned that you can ask, IRP can ask any document for substantiation of the claim, any evidence, cost of proof. I don't think regulation 11 is required for any updation. Then submission of proof of claims, 12A, updation of claims.
Sir?
Yeah.
Sir, I have one doubt here with regard to this updation of claims. Sir, right now, like if somebody wants to withdraw his claim, so there is no specific provision related to that. So should that maybe introduced in the regulations?
Anytime any person can withdraw the claim, and RP has to amend the list and file with the NCLT and take the permission, just the intimation.
Withdrawal of claim
timeline should be given for withdrawal of the claim. I think at least timeline should be given.
Sir, when any person is withdrawing its claim, so what's the harm? They are not increasing their claim, they are withdrawing their claim.
No harm. That's okay. But then there should be some timeline specified for withdrawal when you can withdraw the claim.
Why it is required?
Sir,
Yes.
actually, we have seen one case where there was only one operational creditor and he wanted to withdraw the claim, but the resolution professional said that since there was no clear provisions in the law, therefore he did not allow that particular creditor to withdraw the claim. So, there was no clear provisions under the code. Plus, sir, actually, the regulation 12A, which states with regard to withdrawal of application, that mentions the applicant can withdraw the claim. And if the application is being filed under section 10, then also that withdrawal cannot be put there.
See, Nitika, what happens if any operational creditor filed case for recovery of its dues, right? And now, when he came to know that he has to bear, there is no other creditor and he has to bear further cost of CIRP.
Yes, sir.
Then the question arises कि मेरा 1 crore से ज़्यादा डूबा हुआ है और डूब जाएगा पैसा. When there is no assets in the company.
This may happen to financial creditors also, because financial creditors has specific liability to pay for the CIRP expenses. And
exactly.
If they would be allowed to withdraw the claim and the company has no assets, then certainly they will like to withdraw. So
that's why. So there cannot be a blanket ban. It's depends upon the situations, and RP has to take the decision.
Then in that case, other financial creditors would object to that, because they would have to bear the. They would also like to, if everybody would like to opt out of their claim, withdraw their claim, then
no issue. Then RP can do one thing. RP can make a list of the future expense and ask them to pay and get out of the deal.
Exit before exit, they should pay.
Yeah, obviously. Then only you should allow them to exit. Otherwise,
If
Who
there are
will-
no assets, then collectively they can withdraw the claim. Then the
Sir,
case.
once claim has been filed, there is no provision for withdrawal. And withdrawal comes only in the case when there is no assets in the company. When there is assets in the company, then no one will withdraw the claim.
That is right.
It's practical thing.
Yes.
Sir, are we discussing 12A or are we
Sir?
discussing the claim?
12A, now the 13, verification of the claims.
So regarding
If we are
claim,
discussing the 12A,
sometimes
12A,
one of the creditors may
question of
release the
claim does not
collateral
arise.
and thereby his claim may be reduced. In
Okay.
that case, what to do?
Sorry, come again.
Sir, sometimes one of the creditors may be having collateral other than the that of a corporate debtor. They would have outside the CIRP process, they would have realized it and credited to the account. In that case, the claim amount would have been reduced. In that case, naturally, there should be a provision for that. How to deal with that?
No, if the claim has been reduced, then there must be some evidence for reducing the claim, na?
Yeah.
So accordingly, you can amend the list.
Sir, I have one query.
Mr. Kedia.
In my liquidation case, there is operational creditor.
Sir,
He is-
we are discussing CIRP, Kedia ji.
Sir,
We are
but
discussing-
my case is a bit peculiar. I will be helping, very obliged if you can guide me.
You can connect me out of this forum, then we can
Okay,
help
sir.
you.
Okay, thank you.
Then regulation 13, verification of the claims. Any point to discuss? Any suggestion?
Actually, the time given is
It will
very
be given
short.
adjudicating power in
Based
this.
on the records, we need to verify the claim. And we have to only collate the claim and say that the claim is accepted or not. So the time can be slightly extended.
Yes.
So for a huge amount of 3,000 crore, 7,000 crore, the time is very short to apply with that.
7 days is very less for verification of the claim.
Yes,
In case of
100% actually.
in case of class of creditors, where thousands of claim come.
Yeah, it is very difficult, sir. Thousands of creditors in the case of the flat promoters are there. It becomes very difficult for even the operators to look into it. So more time should be given.
Exactly. So I think that should be. It's my suggestion ki for home buyers or for real estate allottees, time should be more.
Depending on the number of claimants or creditors,
number of
there should be a
Sir,
slab system like up to
we
100
can-
creditors. Say,
we cannot do this now. If how can we know ki there is there 100 claim will come or 1,000 claim will come?
And then that is a on receipt.
In general,
there should be a provision in the act itself.
Minimum
Sir,
15 days.
in my view, for home buyer allottees or for FDs allottees,
It should be 15 days, sir. 15
it
days
should
would
be
be
15 days.
Yes.
Other than those industries, it should be 10 days.
Superb, sir. Very good.
So it's my suggestion. Any other person has their own suggestion? Kindly.
No, I would suggest 15 days in all the cases.
15 case in all cases. Okay.
Yes, yes.
Then when the IRP period will finish?
Sir, let it be 45 days, sir, instead of 30 days.
Okay.
According to the
Let it be 45
timeline
days.
should be increased.
Correct.
No,
Yes, sir.
timeline of 180 days need not be changed. I don't want to change the timeline of 180 days. But IRP period instead of 30 days, maybe
45 days.
Because you give
Exactly.
extension or
That is fine. That's
for
fine.
verification of claim. Be practical. See, we have done many cases. So we know what is really happening. That's why I say that
Exactly.
IRP period.
30 days is 30
Too
days
short.
is very less. 30 days is very
Not
less.
for you to take any call.
Right. Now,
Sir,
14.
I have one query,
More
sir.
suggestion on this
Why
claim.
IRP and RP need to collate only? Why the liquidator have a right to reject the claims? Is there any reason, sir, for the CIRP and liquidation?
Obviously, there is a lot of difference in CIRP and liquidation, sir.
But IRP don't have a right to, you have a right to collate the claims only.
Exactly. They have, sir, आप उसका difference समझिए. CIRP, we are just managing the show to help to revive the debtor.
Okay.
And during liquidation, there is no board of directors. We are the single authority. With the help of SEC, we have to take the decision.
Sir, no concurrence of SEC is required for any such call.
Exactly, exactly.
Call.
Exactly.
Liquidator's call, a liquidator position is much above the position of an RP.
But
he can
yeah, suggestion of SEC is not binding on the liquidator, but they can take the views from the SEC. Everything you have to put before the SEC. Though it is not binding, but you have to intimate with everything with the SEC. And you have to record why you are disagree with the SEC.
No. I am asking collector claims, sir. Claims, not for other. I agree.
I'm just giving you the example. I'm just
are adjudicating. The point is whether you are going to consider the claim or not. If you don't consider, don't say that you are rejected. Your claim could not be considered. That's the technical word you may have to use. If you say it is rejected, you sit on judgment. If you say that it could not be considered, you don't sit on judgment. You have every authority, and the courts have also upheld the non-consideration of a credit.
right. Now next, in 15 regulation 15, I don't think any need.
Sorry, sir. Sorry, I have an issue in regulation 14.
Yeah, tell me.
Yes, I think it's very clear that when you are the RP or the IRP, a claim comes to you, you can deal with it. You know, collate it or say it's not considered. What happens if the COC is already existing and something happened which whereby you are being asked to remove a creditor? It could be a landowner, for example, a judgment. Okay, that previously the landowner became part of the COC, or it could be a guarantee, something like that, and because of judgment or something, you know, is an RP empowered to do that without seeking prior approval from the NCLT?
No.
Okay, thank you.
There is no adjudicating power with the IRP or RP.
Thank you.
He is working just as a postman. Right.
Now, some clarity on the rate of interest in case there is no mention in the agreement or any other document. And different.
ठीक है, वो industry to industry we can discuss. Now chapter.
But in regulation 14, it can be clarified that how the rate of interest should be decided or charged by different creditors, so that the claim admission can be a little bit easier for RP.
Sir, class of creditor rate of interest is already has been mentioned 8%.
And in other creditors, sir?
Sorry?
For other creditors, in case there is no agreement, even some charging the penal interest also.
No, then if there is no written agreement, then there is no interest. They are not entitled for any interest.
But it is better if the matter is clarified in regulations itself.
No, sir. Everything cannot be come under the regulation. Na? It's your duty to verify whether there is any document for that interest.
That's true, but in case such a clarification is provided in the regulations, my submission is only that as a attending it, that such a submission may be made to IBBI and there should be some clarity on it in the regulations.
Well taken. Okay, now next 16 committee with only one OC. Any suggestion? What happens when one OC has filed a case and he did not file its claim? That OC has not filed its claim, and there is no claim received by the IRP. Now what will be the scene? My
No
question.
claim received by IRP. IRP has not received the claim.
Yeah, IRP has not received even a single claim.
IRP may try to contact and request him to file the claim. If even in that scenario, the OC do not file the claim, then
yes.
IRP may move to the NCLT for the closure as new township case has been decided.
Sir, who will pay the cost?
Cost of IRP.
Applicant, he will also pray to the NCLT that the cost must be reimbursed by the applicant.
Yes. That is already mentioned in the regulations.
Yes, sir.
That is already mentioned, but practically it's totally different.
Please tell, sir.
But
Anyway.
here applicant says that he was not knowing that after filing admission of CIRP application, he has to pay. That he takes and he doesn't pay any fee.
That's why I'm saying na, even operational creditors. In one of my case, there were 60 home buyers who has filed the application. Court NCLT admit the case and ask for deposit of 2 lakh rupees with the IRP. Now every home buyer is saying that we will pay as per the claim ratio. So for getting the 2 lakh rupee by the IRP, he has to file the application with the NCLT. So practically it's totally different.
I am struggling for the last 2 years. I am not getting any fees.
That's why I'm saying that. So I think there must be a suggestion that in case of operational creditor or home buyers or section 7, section 8, 9 application, there must be amount 2 lakh, 5 lakh rupee, whatsoever it may be. With the application, he has to deposit with the NCLT. And IRP has claimed this amount from the NCLT.
Correct.
This is my suggestion. At the time of filing of the application,
only when the amount is paid by the applicant, then only the case should be admitted.
Yes.
Should be passed.
And AA should mention that this CIRP cost has to be borne by these people if no amount is there with CD. That also should be there.
That is already in the regulation.
Sir, I have a query here. While filing the case itself, they should deposit the money of 5 lakhs or 2 lakhs, whatever it is.
Yes. To easily, IP can work easily with this fund. Initial working can be done.
Sir, I have a query here.
Yeah, Mr. Prashant.
If there is no instruction for payment by OC or FC in the order itself, then what should be the case?
You should ask for the clarification from NCLT.
Okay.
Yeah.
Because there is a case I am handling and there is not been any such order like that.
You can ask for the NCLT. Otherwise, COC will reimburse. Anyway, 16A, authorized representative. Any point to suggest?
I think many NCLTs are giving an order directing the applicant to pay some amount. That is what I understand from different parts of the country.
Sir, here in 16A, my humble suggestion to increase the fees of AR.
Yes, sir. That again, I'm mentioning it in the discussion paper. It has been doubled.
Yeah.
The proposed amendment for which the discussion paper has been floated, it has already doubled this amount.
So that's why I am putting this question. So everybody shall aware about it. We also write to the ICSI IIP so that they can suggest yes, in our panel discussions, this questions has been raised and whatever the IBBI has mentioned in the discussion paper is fair enough.
Correct. Not only they have doubled that, what they have done is they have suggested the role of the AR has been increased. And
Exactly, exactly.
in the meeting which AR has with the class of the creditors, for those meetings also he has to reduce it to the minutes, and for that meeting also he has been given fees, which varies from 10,000 to 15,000.
Exactly. In home buyer cases, main role is for the AR only.
I agree, sir.
Because he is the point of contact.
Yes.
For
Yes.
all the home buyers.
Correct.
So his work is more as compared to the IRP.
Yes.
I would say like this.
I agree, sir.
Now 16B, committee with only class of creditor. Any point to suggest? No? Okay.
No, sir, it's all right.
If there is only one AR in a home buyer case, if there is only one AR, then the committee will be, and no financial creditor, then the committee will be IP, IRP and the authorized representative.
सर इसमें जब सिंगल ओसी की कमेटी बनती है, in that scenario, whether we require to get the minutes signed in physical form or just their consent electronically will be sufficient.
Electronically consent is suffice.
But if in the recording of the video, because electronically they have not sent any mail or anything as confirmation.
No, then you have to make it signed physical.
Okay.
Otherwise he can refuse. Otherwise he can refuse.
This has happened, sir, in the first meeting.
That's why I'm saying now.
So what is the remedy?
Sir, otherwise in the next CIRP meeting, you can put as a ratification of the previous meeting.
That I have done. Next every meeting I have done for the rectification of the
previous. You are already having recording and everything.
But that minutes will also not signed by the OC.
Yes, sir. But I received after 2 meetings, I received an email from them that the they are okay with that.
Okay. Now your purpose got solved.
I think there is no requirement of getting signature of the COC members on the minutes.
Sir, there is no requirement theoretically. But
we have to calculate it within 48 hours.
Exactly. But practically what happens? They can say it has not been discussed in the meeting. So it's better to avoid the litigation. It's better to do all the work within 4 corners of the law and save our face.
I think the best thing that we actually follow is that in next meeting there would be other matters.
And that we can discuss later. We should stick to this CIRP regulation suggestion.
No. In next meeting, in other matters, we will confirm that yes, in the circulated and he had no objection.
Okay, no issue, Mr. Ranjan. We can discuss it later.
Sir?
Yeah, Nikita.
Sir, in this regulation 16B, where there is only authorized representative, we have seen practically that generally the authorized representative, he generally takes few home buyers with him, and as they want to attend the meeting, which are known as observers.
No.
This is happening. So that should that need to be included in regulation somewhere?
Nikita, see, everything cannot be mentioned under regulation. It's the decision of the IP. He should not do anything out of this box. How can he allow third person in the COC meeting?
Generally, this is happening, sir.
It's against the law.
Okay.
It's against the law. Even IIP or IBBI can take the disciplinary action against that IP. How you allow the spectators in the meeting? It's against the authority which has been provided by the IBC code to the IP.
Sir, whether CD can send the lawyer?
No.
Okay.
Even it's practically happen. Financial creditor say we will send our advocate.
Yes, sir.
But you should not allow. I never allowed. I never allowed.
If COC permit for that?
No. It's your duty to see whether the CIRP is going on as per the law or not.
Okay, sir. Thank you.
You can strictly refuse.
Sir, even
sir, I have one small question in this.
Yeah.
In the class of creditors, if one person is acting as authorized representative for the other remaining creditors, the minutes of meeting shared to the authorized representative, can it be circulated to all the members?
It's the duty of the AR to circulate with all the members.
All the members, even when they are not authorized representative.
No, it's IP will circulate to AR. And AR can circulate with all the members.
All the members.
Yes.
They are entitled for a copy of minutes.
Yeah, they are entitled to ask. They are the financial creditor.
Oh, actually, yeah, I should not ask this. This is in liquidation. I had this question. SEC meeting, they are not financial creditors.
We will discuss it later.
Okay.
You can note down my number. So any queries we can discuss over call.
Can I have your numbers?
I will send in chat box.
Okay, sir. Thank you so much.
Regulation 17, Constitution of Committee.
Pankaj, may I ask one question regarding the meetings? You know, in case of now IPEs have been allowed to function as insolvency professionals. So now in case of IPE as IP, who are allowed to go chair the meeting? I mean, if two people or more than two people can join.
Authorized representative of IPE.
Sir, who are the partner of the IPE? They can chair the meeting.
No, partners all right, but who can chair the meeting? I mean, can two or three persons from IPE, can they join the meeting?
No.
I mean, he is asking how many members, whether one partner or two partner or three partner can also join. That is what he said.
They can, if there are 5 partners, they all can join the meeting. That's not a big issue.
I think his doubt is chairing the meeting.
Chairing the meeting, any partner can chair the meeting.
They have to authorize, na sir. One partner will be authorized.
Yes. So, aisa nahi, it's not so that they will fight for chairing the meeting.
The person who will be the authorized signatory, I think.
Obviously, if it is a company, they will file the board resolution who will chair this meeting.
Now,
even IP team also can join, sir.
In case of an IPE, if an individual is an IRP, now if individual has engaged IPE also, so can he bring the person from IPE into the COC meeting when he's chairing the meeting?
Yeah, if it has been disclosed whether at the time of taking assignments that he is the member of this IPE, then he can cast the duty to its IP partner.
But I think we are deviating from the regular discussion.
Okay, thank you.
Now, Constitution of Committee, Regulation 17, any point to suggest? It's the duty of IRP to file with the adjudicating authority for formation of the COC. Then meetings.
Reputation, I don't think any.
Yes, then meetings of committee, Regulation 18. I think there is no suggestion.
No suggestion required.
Sir, only one doubt, sir. Whether COC meeting to be recorded mandatorily?
Yes, it is mandatorily.
Mandatory? Recorded?
Yes.
Whether it can be conducted in a Google Meet?
So what?
These two things.
So
Google
what?
Meet permitted?
Yeah, you can.
It is not a secured environment, they say.
So long the RP ensures the confidentiality, we can use any platform.
Regulation 20, service of notice by electronic means.
Sir.
Sir, one clarification.
We have to videograph that meeting, physical meeting.
Yeah.
Physical meeting has to be videographed.
Okay, thank you.
Regulation 20, service of notice by electronic means. Any suggestion?
Sir, one doubt, sir, one clarification, please.
It's regarding regulation. Any suggestion on regulation 20?
Sir, what is 19, sir? 19 missed out.
20, 19
19
same. 19 for meeting of the committee, part of that heading only.
Conduct.
Yeah. 20, service of notice by electronic means. Any point to suggest?
No, that's.
I don't think there is
normal
any
thing.
point.
I don't think. Yes, yes.
It's okay.
21, 22. It's the practical thing. Nothing. It's well drafted. Nothing to improve. I don't think there is any point.
Quorum and all, it's all already decided. That is not
Yeah.
going to die.
Then participate through video conferencing 23.
Yeah, we are allowing them nowadays. There are now more platforms are available.
Yeah, then 24. That is the main thing.
Sir,
Where
while
to-
conducting the meeting, bankers should be somehow or other educated to at least to tell their name and designation.
No,
Simply they
sir.
participate without
Sir, it's your duty to take the authority letter who is going to attend the meeting from their seniors. I did not allow any person, PNB GM, once in my one case, PNB GM attended the meeting. I asked them, I will not allow to attend the meeting unless you will give me the authority letter from your higher up. And I did not allow him to attend the meeting. Authority letter with their banker's ID proof. Two things you have to keep in your records. Otherwise, question will be raised at the time of inspection. Right?
This comes under regulation 24. Sir?
Yeah.
Okay.
Because IP, what the IP fears, if I will say something to the bankers, then next time they will not give me the case. It is the general tendency. But you should stick on your law point. You can adjourn the meeting unless and until they will not provide you the required documents. Any voting by committee? Regulation 25. Any suggestion?
Pankaj, are the minutes of the meeting of the previous committee meeting to be confirmed in the next committee meeting?
Once if it is confirmed through signing or and all, then you can minutize that previous meetings has been signed by all the stakeholders. Then 25A.
In board meeting, we get the confirmation. Similarly, can we get the confirmation here or not required?
Sir, if they have signed the minutes already, then you can, in the next meeting, you can mention, you can narrate that every participant had signed the previous minutes of the COC meeting.
Just a mention, not to be circulated with the agenda.
No, just a mention.
Thank you.
It is signed.
Thank you.
25A, voting by authorized representative. No suggestion. 25(6), voting through electronic means. Yeah, here is a suggestion. Practically what happens if we conduct COC meeting today?
Are we discussing 26 today or you said 1 to 25?
Sir, now we will close it because chapter 8 will start from the regulation 27. Okay. So we will close by voting here. So practically what happens when bankers are attending the meeting, they say that they will take the decision after asking the higher up. But as per the notification issued by the IBBI in year 2018, only those persons should attend the meeting who are authorized and who have authority to vote.
Practically, it is not possible.
Sir, what happens if there is only one financial creditor and he is attending the meeting? Then why to make the expense on e-voting when they can vote at the spot? But practically it happens, they say they will ask for the higher up and then take the decision. You open the window for e-voting.
Yes.
So that it means if they violate the IBBI notification, or IBBI notification has no meaning in that case, when they are not able to take any decision.
IBBI's rule is not, regulation is not practical.
Yes, it's not effective.
Because I'm an ex-banker, I know the practical difficulties.
Yeah, any point on 26, regulation 26?
It should be amended accordingly.
It should be amended accordingly, right.
And even if you will put a voting item in the agenda items, they will not prepare and they will not take a proper higher authority approval. After the meeting, again, they will send, we need to send a memo to higher authority and a request for the 5 days working days for the e-voting window opening.
Practically, COC members are killing the precious time of IP.
Sir, not only COC and NCLT also, within 14 days, they need to admit the cases. It is not going back. And
Sir,
only
no.
IBBA, we are not commenting, sir. How we need to improve that we are thinking. Okay, everyone, all experienced people, everyone knows where we are lacking. I will not pinpoint anybody, sir.
Sir, nobody can raise the finger to the court.
Yes, yes. No, sir. There is a lacking is happening. Not only COC, that point of view I'm telling. I'm not blaming anybody.
Exactly,
because of their rules and regulations, so some exceptions is there. Everywhere some leaking is there. That I'm trying to say.
Right,
Okay. But
IBBI has to think timeline shall not be mandatory for IP also, as it is not mandatory for the NCLT.
That is only applicable for IP, sir. Whether you will get COVID or not, they will not bother. They are looking for
everything is mandatory for IP.
Yes. And the second thing, if any delay or any submission of forms also, we need to check what is the material impact by the IRP or RP not done.
Exactly.
That is not going on. Okay.
Anyway,
there is
here is one request to all the participants. We have covered from regulation 1 to regulation 26 today. Even though you have missed anything, or you recall that you have to give your suggestion.
Yes, sir.
We are giving you an email ID. Nikita, share your email ID in the chat box. So any participant can send a suggestion on that mail ID, so that we can forward the same to the IBBI.
We need your phone number, sir. Also, आपका phone number भी चाहिए, sir.
Sure, I am sending.
Thanks a lot, sir.
So Nikita.
Yes, sir.
So formally, you want to say something? Over to you. Thanks to all the participants for patiently giving suggestions, for participating in the discussions. And I would like if everyone participate and give their suggestions through mails. Thanks a lot.
Thank you, sir.
Thank you. Thank you. Thank you to all the participants, and thank you, Pankaj sir, for moderating the session. I would request all the participants to gather on next Wednesday, and the topic will be the remaining CIRP regulations and fast track CIRP regulations also. So kindly keep the suggestions handy so that we can submit some fruitful feedback and suggestions to IBBI.
Thank you.
Thank you.
Thank you. Thank you.
Okay, sir, we meet next Wednesday.
Thank you.
Thank you, everyone.
Thank you, sir.